All right, and our next story is another example of shocking remarks coming from people in positions of power and responsibility. Now, in a controversial, rather blindsiding order, a Kerala Sessions Court has granted bail to a 74-year-old activist and poet in a sexual harassment case. Now, the Sessions Court in its order said that the complainant herself was exposing by wearing a dress which was sexually provocative. Hence, a case of sexual harassment will not stand prima facie. Now, the court further questioned how a 74-year-old man with physical disability forced himself upon a woman. Now, the court also observed when there is a long delay in lodging an FIR, then the reason for the delay must be properly explained. And in this case, the FIR was lodged only 2 years after the date of the crime. And my colleague Vivek is joining us live on the broadcast for more on this. Vivek, if you could first please take us through the details of the case and then the observations that the court has made.
This particular incident took place in 2020 in a poetry meet. This happened in Nandi Beach in Kozhikode back in 2020, the month of October, where activist Civic Chandran, he's also a social activist and a writer, a well-known writer who is quite known in northern parts of Kerala. He has written many books. He has come in television discussion panels many a times. In this particular poetry camp that was held in Kozhikode Nandi Beach, Civic Chandran is alleged to be sexually harassed a young writer, and now that the complaint has been filed, now the Kozhikode Sessions Court has taken up this matter. And today, what's more shocking, the most shocking thing that happened today was the remarks that's been made by the Kozhikode Sessions Court, saying that the offence under section 354 of the IPC will not stand because the complainant, that is the victim, the writer, is wearing a sexually provocative dress, and hence this particular charge does not stand. Also, the order says in the point 10 of in the last paragraph in the order, it's said that the writer, he's got disabilities, he's 74-year-old, and how can he force upon himself on the complainant in a health condition like that? So these are the kind of comments that's been made by the Kozhikode Sessions Court. This has led to a major debate in social media, and also in various circles, especially in the socio-cultural circles, and even politicians have spoken about this. The Women's Commission chairperson P. Sadi Devi, whom I spoke to morning, has put out a Facebook post, and she spoke. When I spoke to her, she said this cannot be accepted, and especially by a court, by a magistrate, and a statement of this order coming from a magistrate is something that cannot be accepted, and it's up to a woman to decide what dress she wear, and a court deciding, saying it is sexually provocative is something which cannot be accepted. This is highly uncivilized, and what we understand is that this matter will be taken up in the higher courts, because this incident took place in 2020. Remember, the FIR was filed this year, and many a times the court has heard this case, and shockingly, this activist Civic Chandran, the writer, has got an anticipatory bail, and while submitting the bail application, he has also submitted the photographs of the writer. And looking at all these, citing all these, the Kozhikode Sessions Court has made this controversial order, which has been criticized by many people, saying that a magistrate should not have made such a comment, such a remark, which is something cannot be accepted by a civilized society. Back to you.
Right. Many thanks, Vivek, for joining us on the broadcast and taking us through all those details. All right, I'm now being joined by Advocate Shabina and also by activist and lawyer Flavia Agnes. Many thanks for joining us here on Mirror Now. Let me go across to Advocate Shabina first. Ma'am, the Kerala High Court today, I beg your pardon, a Kerala court today said that sexual harassment complaint will not prima facie stand when a woman was wearing sexually provocative dress. So, do you think, can a nature of outfit worn by a woman be a ground to absolve a sexual offence?
First of all, I'm also shocked by the news. I'm also shocked seeing the judgment. I must say that the manner in which this issue dealt is pathetic. I must say that because I have gone through the judgment. I am just reading it even now, the judge says that section 354A will not prima facie stand against the accused. You should see the reason. The reason stated that there must be sexually colored remarks and also the photographs produced along with the bail application by the accused would reveal that the de facto complainant herself is exposing to dress which are having some sexual provocation on. What are you even saying? We are in 2022 and we are a judge himself is speaking about all these things. He is showing the audacity to write this in a judgment. I don't understand how and why. I'm also shocked. I am having my own limitation to comment on this issue because being the part of the system, I'm also having my own limitation. But still, this is pathetic.
Right. Let me also get in Miss Agnes on this. Ma'am, do you think this is not giving credence to the highly misogynistic idea of she asked for it?
Absolutely. Absolutely. Because you cannot judge a case of sexual harassment by what the judge thinks it is harassment or not harassment. It is the victim who must say that who has filed a complaint for experiencing sexual harassment. So how can the judge prejudge the case at the anticipatory bail case stage and grant anticipatory bail to the accused person? This is preposterous, and this shows the mindset of the Kerala society as a whole and also the judiciary as a whole. And because we keep getting cases like it, cases after cases of this nature, and what a woman, she has every right to wear what she feels like. We see Hindi movies, we see film stars, we see society in general, where the women have the freedom to wear whatever they feel like. And a guy, 74-year-old, cannot give an excuse saying that because she was wearing certain type of clothes, that she was inviting trouble for herself. And not only that, he says this, but the court accepts this. And I think that is very, very strange. That is a big step backwards for the women's movement, who fought so hard to bring these cases of sexual harassment to the limelight. And most of the people who harass are people in established position. So in this case, a social activist doing this, 74-year-old, and the court has taken totally his side, saying that because he's an old man, because he's 74-year-old, because he's suffering from certain physical challenges, that he's incapable of doing, making colored remarks or sexually tinted comments or physical touching, and that the woman has to be taken full blame of her way of dressing, so that he is left scot-free. And it has got implications for other cases of similar type. How will women come forward and fight cases? That is just will be a great setback, because women will be extremely hesitant as to what comments the courts are going to make about their own character and their own conduct.
Right. Let me also get in Mr. Beena on this. The court, as Ms. Agnes was pointing out, the court also expressed disbelief that the 74-year-old physically disabled accused could forcefully put the de facto complainant in his lap and, touch their private parts. So do you think, can age of the accused be a factor in application of sections related to sexual offense?
It should not be. Let me correct Madam Agnes first of all, because he is not a representative of Kerala society. We cannot generalize the society for this. This is not the general mindset of the Kerala society, first of all. We are feeling bad about this, especially about this judgment. As you already said, there are courts hired to this court. We should see it there. Sorry, I missed your question there. What was your question?
No, what I meant to ask was, since the court also pointed out the age of the accused. So can the age of the accused be a factor in the application of sections related to sexual offense?
It cannot be, and it should not be. If you ask me, it cannot be, because as 75, every person is different, right? First of all, this judgment itself is absurd, because I must say the judgment itself is absurd because you cannot simply judge it from a person's perspective. First of all, a judge is not supposed to put the shoes of a accused to himself because he should think from the perspective of the victim, not from the perspective of the accused. Therefore, putting his age and clearing things for him and showing a good path for him is not good for any person, and this is not the way to treat it.
Right, right. There's another observation that the court has made, and that is about a long delay in lodging of an FIR. So, what do you have to say about that?
See, that cannot be said because we are in the middle of a Me Too movement which is being celebrated because people are coming, girls are coming after 2 or 3 years or even 5 years saying that I have been harassed once, I have been sexually abused once, and these issues should be taken seriously. There is no court which is not encouraging it. There are higher courts in this state which says that this should not be generalized, this should be encouraged because these movements should be encouraged because finally people are coming out from their caucus and they're just saying that we were the victims. Therefore, the year-wise calculation and saying there is no explanation for these 2 years delay is absolutely not correct, absolutely absurd. This will not stand.
Right.
This is just the opinion of a person, right? We cannot call him the pillar of a judiciary or what. This is just his opinion. I should say that because I am saying this as an opinion of a judge. We will go through this. We will take steps to get this away. We will take it to higher courts.
Right, right. Miss Shabina, Miss Agnes, any last comments that you would like to make?
I would like to apologize for that comment on the Kerala society. It should be on the judiciary in general. And this is what our judges think, and that is very, very disturbing what they think about women in general. So it could be a court in Kerala, it could be a court in Karnataka, or it could be a court in Maharashtra. But we have this extremely regressive judgments coming up. But today there's also a very positive judgment coming from the Supreme Court, where it says that even if the woman is at home and she's being sexually harassed by messages and comments, etc., it still causes sexual harassment. And it cannot be only on the streets or outside, but it can be in their own home also. So that's a very positive judgment from the Supreme Court. And we hope that there will be counter remarks against this judgment by the higher courts, and the case will move forward because it cannot remain at this stage.
Right. Right. Miss...
I wish to add that judiciary is not free from any kind of criticism. We should criticize whenever we see this, and this kind of discussions will definitely help. We hope this will definitely help.
Right. Miss Shabina, Miss Agnes, many thanks for joining us here on Mirror Now and sharing your views.